guardianships, but there's but there's still plenty there. Um, so with that being said, let's just go ahead and get started. And I'm going to advance my slide and do the same things that you probably do every time you talk to someone, which is make it clear that you're giving legal information and not legal advice. And since we're going to be talking about a couple of scenarios today, just pointing out, of course, they're completely fictional and it's not related to any person, living or imagined. So before we hop into the scenarios, I'm going to spend a little bit of time maybe reiterating a bit of what we talked about back in October. And the importance of this is because with the change in the law, there's an even greater emphasis on aspects of guardianship law and other protections for vulnerable adults that don't involve a guardianship. And so a huge part of guardianship law is really thinking about what else can be done that isn't a guardianship. And that's really one of the huge emphasis in the law. And so when we're going to head into these scenarios, we want to think about what implications that has when somebody might show up, at your office with some questions. And one of the basic building blocks is to recall that basically every potential adult guardianship situation is unique. And that's because people can come into guardianships for just all kinds of reasons or have it being considered by their family members. There can be age-related dementia type situations. And there may be people who have or have not done some advanced planning. You can have somebody who maybe has a traumatic brain injury from an auto accident or something, or a stroke, and maybe it's happened to someone who's in their 30s and 40s, and maybe they haven't been doing any sorts of planning. People may be coming as someone who has lifelong intellectual or developmental disabilities. So there's lots of different reasons why someone might be need to have some protections in their life. And even within those categories, there can be a lot of variation because, as we know, dementia can go from very mild to very severe. Brain injuries or strokes may involve recovery and may have different variations of how much. And same thing with sorts of intellectual or other types of developmental disabilities that can really represent a wide range of variations within all of those categories. And so that's just that sort of appreciation of that background fact is super important. And how does that impact you and what you're doing if somebody comes in and says, well, I want to file a guardianship? Well, this impacts the whole world of adult guardianship in that maybe in a lot of other kinds of cases, people really know what it is they're seeking. If it's a marriage, if it's a divorce, a dissolution proceeding, there's obviously individual unique characteristics there, but people usually know that I want to end this marriage. Sometimes when people are coming to petition for a guardianship or to pursue that, they're not necessarily sure what they need. And there's a little bit of a chicken and the egg kind of thinking process involved as well, because people are going to need to think through what they want, and that requires to have them consider beforehand what other things might they pursue that is not a guardianship. And so whether somebody might be looking for a guardianship, sort of that personal decision-making authority, might they be looking for the conservatorship, which is that financial decision authority? Are they looking for both? Are they looking for a protective arrangement? What does that mean again? And even before you get to that kind of preliminary consideration, are there other options that they want to look at beforehand? And they're going to be encountering those questions right from the get-go. Because if someone is going to be petitioning for a guardianship, and I've excerpted a page here from the state model forms, a couple of the aspects that have to be described is why does the person need a guardianship or other arrangement? And then it asks the person, the petitioner, to describe, well, what's currently in place? And also, if there isn't some alternative in place, has that been considered? Has it been tried? Why not? So as soon as somebody's getting to that petitioning, they're going to have to answer that question. Did you consider other options that might work for this person that aren't guardianship? And so that's why people will need to go through that thinking process, but they may or may not have done that by the time they're showing up thinking they need to file a petition or start a case. And that all relates to what's in the petition and what they're going to be wanting in their order if they do want a guardianship. The court is going to need to find that there's clear and convincing evidence about that need for the guardianship or protective arrangement, and that a less restrictive alternative isn't available. So clear and convincing evidence that these other things don't work before a guardian can be appointed. So that's why your petitioners are really going to want to consider whether there are available alternatives before they go to the trouble of petitioning. And that will save them a lot of time, trouble, filing fees and other things, because if there are less restrictive alternatives that are available that are going to meet that individual's needs, the petition is going to end up being dismissed. And so that's not a useful enterprise. Now, that isn't always known, but let's go into our first scenario and kind of look at what this might look like. So I am just going to read this aloud to you, so bear with me. So our first situation is going to involve a young man named Jeremy. He's a young man and he has some intellectual disabilities that he's had from birth, and his parents, Alice and Stan, have been told by someone out in the world that they have to get a guardianship when Jeremy turns 18. So Jeremy has an IEP at school. He is enrolled in school and is interested in pursuing some vocational training. And he's pretty high functioning, pretty independent. He has a part-time job. He takes public transportation on his own, has a lot of ability to handle a lot of aspects of his life fairly well. But he does have some intellectual disabilities, and one particular issue that he has is that he really doesn't have any impulse control about spending money. And if he gets money, he will want to spend it immediately. And concepts about needing to pay bills over time and budgeting are just something that are not within his capabilities. And Jeremy is going to inherit some significant funds from his grandmother when he turns 21. His parents know this. Jeremy has a couple of adult sisters, Maria and Lindsay, and he lives at home with Alice and Stan. So here we have someone who's kind of got a mixture of abilities, but some areas where maybe his decision-making ability is not great for some aspects of his life. So again, before these petitioners are going to decide to whether to go forward and file a case, well, their question will be, well, it should be, is a guardianship or a conservatorship or a protective arrangement, is this necessary to start the case and get it going? You as a facilitator can't answer that question. That's not something that you or I could answer. But what can happen is that the petitioners can be informed that in that petitioning process and part of their case will having to answer that question, which is, are there other alternatives that might meet Jeremy's needs for assistance that don't involve setting up a guardianship? So are there other less restrictive alternatives? That's really a threshold kind of question. And some examples of that might be things like a power of attorney document or a supported decision-making agreement, for example. Now, these executing either of those documents does require that Jeremy has enough decisional ability to be able to do that. And his parents may know that, or they may need to seek more information from treatment providers and evaluations. But those might be potentially some options. Again, since that is not something that you as a facilitator are going to be assisting with, what are some resources you could send Stan and Alice to? Well, Washington Law Help has some sections on both durable power of attorney documents and supported decision-making agreements, things that these Stan and Alice can read about and see whether or not it looks like that's something that might be a fit for Jeremy for his purposes. I'll also throw out there that our office offers monthly information sessions, which include descriptions of some of these alternatives. That's something that you could also send folks to, but those are some preliminary questions, again, that people will want to think about. And so then there's really kind of decision points there, because if the petitioners need to spend some time thinking about whether some less restrictive alternatives might be available, they may want to do that, and that would be something they would do, which again, that's not a court process. That's something that happens outside of the court case. Or perhaps they do find that they do need a guardianship or a conservatorship or a protective arrangement. Now, what's kind of important to realize is that there's some possibility of kind of slice and dice, you might call it, in the sense that some person might be able to meet some of their needs through some less restrictive alternatives, but might need one of those things, a protective arrangement or a conservatorship, for other aspects. So it's not necessarily a total one or the other. It could be a combination. And so that's what we're going to look at when we're thinking about our young man, Jeremy. So let's say that Stan and Alice, Jeremy's parents, have decided to consider whether or not some of these other less restrictive alternatives might work for Jeremy, because he's quite high functioning when it comes to things about like making decisions about the vocational training or maybe where he might want to live if he at some point moves out of the family home, other sorts of things, but maybe he needs some assistance with perhaps obtaining information about different vocational programs, or maybe if there's some complicated healthcare decision making. Some of those options instead of guardianship might work really well. And so Stan and Alice may decide that they're going to be his support under a supported decision-making agreement. In the supported decision-making agreement, Jeremy is going to remain the decision maker, and Stan and Alice are just going to be what are called supporters. They're going to assist him in some of those types of decision making. But a court isn't giving someone else authority to make those decisions. Jeremy remains that person, making his own decisions about that part of his life. A power of attorney in favor of his parents is another option he might have. Again, that will require a certain amount of decisional ability, and that is something that happens outside of the court process. But that might be an option that Stan and Alice really decide are appropriate for Jeremy. But let's think about those other aspects of Jeremy's life that perhaps his decision-making ability isn't really enough to protect his basic needs and in terms of managing his finances. Because remember, in our scenario, Jeremy isn't really able to have impulse control about managing money. If he has it, he wants to spend it, and he is not really got the sort of decisional ability to capably manage his funds over the course of his life needs. And so then a power of attorney, well, that's a revocable document that isn't going to necessarily provide enough protection for Jeremy, because he may execute it in favor of his parents, but if he comes into those funds from his grandmother, he might want to spend it all and just no longer and revoke that power of attorney. Same thing with supported decision-making agreement, because the person retains the ability to make the decisions and just has supporters assisting them. That might not be sufficient for Jeremy, because he doesn't have that decisional capability to protect his needs and appropriately manage his finances for the long term. So those options, may not be on the table for Jeremy. So in that case, Stan and Alice might think, well, we do need to file for a conservatorship so that they can be appointed as conservator for those finances. Or, and here's just a possibility, maybe there could be just a protective arrangement for Jeremy's finances, just for those funds he's going to inherit from his grandmother. So let's dig into the facts on that a little bit more. What's a protective arrangement? Just to remind you, a protective arrangement is something that is established in the same way a guardianship or a conservatorship is established. The case goes forward, court visitors appointed, there are findings by the court that the person doesn't have sufficient decisional ability in this subject area. But instead of setting up a conservatorship, which like a guardianship, except for respect to money, just something more limited will meet Jeremy's needs. And so if Jeremy's never going to have a lot of funds in other ways, with respect to, say, wages, limited, so on and so forth, maybe it's just that big bulk of funds that he'll be coming into that would need to have some protection. So maybe the court could order that a trust be established for the inheritance so that Stan and Alice can manage that for Jeremy's needs over time. Now, whether or not those things are a possibility and whether or not a full conservatorship, probably something that Stan and Alice have some ideas about, but whether or not that's the right and appropriate fit, well, that's what the case will be about. That's when we talk about a little bit more about what the court visitor will look at. That would be part of what they would be recommending to the court. Are one or the other of those something that's appropriate for Jeremy? So I know this gets pretty complicated and convoluted, so I know I'm throwing a lot of information at you, but I really want your take-homes to be making sure that folks are being informed that they need to consider what's called less restrictive alternatives, things that happen outside the courtroom. And then if they do need a case, to file a case, even within that, thinking about what's the least restrictive that they need to ask for. But here's an important piece of information. The court can convert a conservatorship petition, for example, to a protective arrangement petition, or could convert, someone could file for full conservatorship and the court can order limited. So there is that process in the court process that can look at that and come to the ultimate. People don't need to necessarily know what the end result will be, but just that they're considering what are the alternatives what's the least restrictive that they think is appropriate to meet that individual's needs. And so for Jeremy, in Jeremy's situation, Stan and Alice may decide, well, for the time being, Jeremy's capable of making his basic personal life decisions with some assistance. So maybe they will do a supported decision-making agreement instead of having a guardianship. But they do feel that Jeremy's not capable of managing those finances. And so they're going to opt to petition for conservatorship. Does anybody have any questions about all that? I know that's a lot of information. So now that they've determined what they need, looking at the petitioning process and what do Stan and Alice need to do. Well, to start the conservatorship, they're going to need to file their petition and just fill out the appropriate parts. They're just going to be petitioning for conservatorship. They'll need their 101, the notice of the petition being filed. That's an important document that goes to the respondent, so to Jeremy. He'll need to get that document that lets him know he may be losing some of his rights if this case goes forward. Because the presumption in adult guardianship is always that we're all presumed to have the ability to make our own decisions. And the guardianship process or conservatorship process gives some of that decision-making authority to someone else. And so that's why people need to get this notice. This is how, your life may be changed if this process goes forward. The other important piece that people will need is they'll need to get a court visitor appointed. So the court visitor, if you've been dealing with these, like the old guardian ad litem, is that person who gets appointed off the rotation, who's going to go out and interview Jeremy. They're going to interview Stan and Alice. They're going to get a professional evaluation. They'll look at treatment records, and they'll make a recommendation filing their report to the court. But they're going to need to get appointed, and so your petitioners will need to get that order, however that works in your county. Your petitioners, Stan and Alice, are going to need to get the hearing set. It needs to be at least 60 days out, and then get that information to Jeremy as respondent, to the court visitor, and they may need to use the GDN all 1001 if there's information that they want to protect about finances, about health, or other personal sensitive information. That's the form they'll be using for that. And so if they've filed their documents, gotten their court visitor appointed, and have their hearing date, they're going to have to arrange for personal service. Very important, and you know that better than I do, what that entails, but basically personal service within 5 days of the petition being filed. They're going to need the copy of the petition, the notice of the petition with that important information about rights, and the notice of hearing to be personally served on Jeremy and the court visitor named in the order of appointment. Now, a couple little asterisks there. You may be familiar with some court visitors in your county may accept service by email. That's something that they may do, but just to be sure that that's a known fact and not assumed, and that it must be personal service on the respondent. And that's really important, because that's what's called jurisdictional, meaning the case can't go forward unless Jeremy's personally served. The question in the chat is, so the court visitor is appointed ex parte. Really how that's done by each county is individual, but I think that in a lot of counties it is done ex parte. You can just get that court order. I always have to be careful about saying how something's done in every, because there is variation in how that process goes in every county, but in many counties it is done ex parte. So when we're thinking about adult guardianships, there is something that is similar to minor guardianships, which you may be more familiar with. So you know that in minor guardianships, there's kind of tier 1 and tier 2. The tier 1, the people who have to get the personal service, the minor if they're 12 and up, the parents, so on and so forth, and then the other folks who need notice. Well, it's just the same in adult guardianship. So the respondent, in this case, Jeremy, and the court visitor need the personal service. And then there's a list of other folks who must receive notice. And so that is, there's an exhibit list in the petition, which basically says what's in the statute. And here's the other folks. Now, something to be aware of there is, in the statute is to the extent these folks are known, because it will list a lot of people. And depending upon who's petitioning, they may know who, where is the, adult stepchild, blah, 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 or whether or not somebody had an attorney or caregivers. Sometimes the petitioners are going to come in and they won't necessarily know or be able to identify those other people or know where they are. So the other folks on this kind of tier 2 list for adult guardianship, just like with minors, that's to the extent they're known or they can be identified. So in Jeremy's case, it's going to include adult siblings. So his sisters, Maria and Lindsay, must also receive this notice, but they don't need the personal service, so they can, have it mailed or hand delivered or what have you. But it will also be the copy of the petition, the notice petition and rights, and the notice of hearing. And this doesn't have to be within that 5 days, but in general needs to be at least 14 days prior to that hearing that's set out. So something important in the case is that the judge or commissioner is going to need to know that that personal service and notice to these other folks was given. So per statute, that has to be shown at or before the hearing, has to be filed in the case. And again, just like the difference in the minor, there's the forms for personal service and for other kinds of notice. And so it's the same forms, which these were separated out in last July, so that there's the form for the proof of personal service, that the process server, not Stan or Alice, evidencing that Jeremy and the court visitor were served, and then the 009, the proof of service other than personal, that Stan and Alice can do, evidencing that Maria and Lindsay were served copies of the documents. What are some other steps or other things that need to be done? Well, if Stan and Alice are proposing themselves to be co-conservators for Jeremy, then they're going to need to file the disclosure form, the GD, and all 002, giving their information about sort of criminal history and financial history, in terms of filed bankruptcies, that sort of thing. They're going to need to demonstrate to the court that they've taken the lay guardian training. So that's, again, available on our website. That's required for non-professionals to take the training. So if you go to the Guardian portal, it's going to, have the module just available. Things to know about that is that it used to be a more complicated system where folks had to have a password, so on and so forth. It's been, updated and modernized so people can go in, and it's basically compatible with all browsers, which sadly was not always the case. But folks can go in and do that on their own time. And then they're going to need to file, it's on the same page, just scroll down, the declaration of completion that they're going to need to file with the court to show that they have taken the required training. And the training is important because that's going to tell them a lot of important information for them going forward. Like, what do I have to do once I'm appointed? What documents do I have to file then? What do I have to do at 90 days? What are my periodic reporting? How do I make decisions? when do I have to ask the court for permission or instructions about things? It's something people can go back to, but it is an important bunch of information available there for them. Now, when we're thinking about this, there's some other questions that come up, and this is something that actually our office gets quite a few calls and questions about actually from time to time. And that is, can you file, could Jeremy's parents, Stan and Alice, could they file that conservatorship petition before Jeremy turns 18? And the answer is no, because, and that does create a little bit of a gap. And that's just the way that the law is, but because everyone's presumed to have the ability to make their own decisions, and adults presumed to have those capabilities. So you can't file a case against the adult taking away my adult rights until I'm an adult and able to respond in that way. So folks can go ahead and get ready, and you can encourage them to be all ready to do that so it can go forward, but the actual filing shouldn't happen until that young person turns 18. Some other questions that folks might have, will Jeremy participate in the hearing? Does he need to be at the hearing? To that is yes. In general, respondents in guardianship proceedings need to be a part of those hearings. There are some limited exceptions if someone has been informed that they can lose rights and they just consistently, they don't want to participate, or in situations where someone can't participate meaningfully. Maybe somebody's been in a terrible accident, they have a brain injury and they're unable to take in any information. Obviously that would be a reason why somebody wouldn't have to, but in general, that individual will be attending the hearing. The court's going to want to put eyes on them, hear from them, and get a sense of their feelings about the situation. So that's an important piece. The court visitor in general, all the costs of the proceeding generally get charged to the individual. So court visitors' fees will either be charged versus Jeremy's assets, depending upon how much assets he has, or if someone doesn't have many assets, then maybe Jeremy has no assets because he's just going to be turned 18 and has a part-time job with very little money. And so that case, the court visitor fees will be charged to the county. And parents may also ask, can Jeremy have an attorney? Stan and Alice may say, yes, the court may appoint one if they feel he needs one, or if he objects and is of limited assets, that also will be at the county's expense. And so that's something that may happen, and the attorney's job in that case is to advocate for whatever it is that Jeremy wants. All right, I'm going to take a quick sip of water here. Thank you. All right, so that's Jeremy's situation is one kind of situation, and one that's pretty common. I'm going to put a little spin on that, or variation. So a lot of times you may have parents like Stan and Alice who are coming to consider a guardianship for their child that may have intellectual developmental disabilities. Jeremy was pretty high functioning. We saw that he was able to make quite a bit of decisions and about his personal life without needing to have protection, but not so much when it comes to finances. Maybe another situation is that the child needs help in all aspects. But unlike Jeremy, their only income is ever going to be, absent something unusual happening, Social Security income. This is a much common scenario. That's the person's only income. In that case, they may just need a guardianship and could have a rep payeeship for that SSI funds. they don't need a conservatorship. There's no financial management to go on. And if they only have Social Security income, that can be done as a less restrictive alternative outside of the court process, because it's just those limited types of funds. Let's pop now into our second scenario, which is going to be about Annabelle. So here we have a little bit different situation. Here we have Meredith and Rob, and they're concerned about needing a guardianship for Meredith's aunt, Annabelle. Annabelle's 79 and she still lives in her own home, but she's kind of has been becoming forgetful over the last few years. And now she is really exhibiting a lot of confusion and doesn't seem to have a handle on things too much at all. She doesn't remember to take her medication, and sometimes she isn't sure has she had meals that day. Can't quite remember. She's not really paying her bills on time, and so she's had her cable cut off and her cell phone cut off. Don't know about her taxes, but probably looking like that probably hasn't happened. And she does have a lovely home, but since her husband Albert passed away a couple of years ago, she hasn't really been paying attention to maintenance. And now the roof has a leak, and that's causing damage to the interior. So there's a problem there. But Meredith and Rob might have, limited knowledge of Annabelle's, personal and financial affairs, and maybe don't know what she has put in place. Just like with Jeremy or any of these, again, our starting place has always got to be, are there other options other than having a conservatorship case? So they're going to need to start with that same inquiry, or should be directed, have you considered whether there are other alternatives that might meet the situation? And again, as we said, as a facilitator, that's not, your job to advise them, but you can inform them that they really would want to see whether or not that's an option. Because maybe Annabelle did execute a durable power of attorney for healthcare and finances in favor of someone. And is that information they can learn? Is that person that she may have appointed, maybe they aren't even aware, but they are willing to act on her behalf, to the extent they can figure out any of that stuff before they go to the trouble of filing a case. That's something they're going to want to do. But in these kind of situations, sometimes Meredith and Rob may not have enough knowledge about her situation to know, are there valid options? Has she done that? Well, you don't know. They can't go rifle through her safe deposit box or other things without authority to do so. And so if they really aren't able to determine that within reasonable, then they may need to just go forward, and that will come out. So they may opt to file for guardianship and conservatorship because they're concerned about her health and safety if she isn't necessarily taking her medications or getting proper care, eating well, getting adequate nutrition. And if she's having these financial management issues, she's not paying her bills, this leaking roof is going to ruin the house if that keeps going. If her taxes haven't been paid, she's going to have penalties that'll mount up. And if they aren't able to determine that and go ahead and file, and the court visitor will have the ability under their authority, under their appointment, to report back on whether there are some of those other options. That's one aspect of what the court's visitor's job is to recommend whether or not guardianship or conservatorship is appropriate, or are there some other options that were out there, because that court visitor is going to be able to go gather that information, which the family may have, but sometimes they don't. One question or query that Meredith and Rob are going to think about is there a need for someone to be appointed sooner than setting up the, under regular guardianship, the hearing's got to be at least 60 days out. Is it a situation where they might need to think about doing something sooner? And so would an emergency guardianship or conservatorship possibly be an option? Could they ask for an immediate ex parte appointment of an emergency guardian? You're going to look at those. And again, if you've been doing your minor guardianships, that's going to look a little bit familiar, right? Where you have your regular track. Now in minors, now you can get the emergency and immediate within the regular guardianship track. But here, are you going to need to file this separate emergency guardianship to get something going sooner? Well, just like minor guardianship, it's a higher burden for them to show. So they're going to have to consider whether or not, if they're going to ask the court for an emergency guardianship, they're going to have to show that it's likely to prevent substantial and irreparable harm to the adult's physical health, safety, or welfare. So if we're thinking about Annabelle and she's not taking her medication, it doesn't appear that she's taking that regularly, that may depend on, well, is it a medication that is very important to her health, that she is taking it all the time, or is it her multivitamin and something? If it's something where you need to get some action on that sooner, then maybe that's something that you can show that Annabelle really isn't getting enough nutrition, and you're concerned that she's really going to suffer some serious harm by not taking her medication or getting appropriate nutrition. She needs to be perhaps moved to somewhere where memory care, or somewhere where people can attend to her needs. So those are the things that would be considerations for Meredith and Rob, if basically really there is this real likelihood of significant harm, and it can't be figured out again by some other way, because that's something you're going to find in every single time, that people are going to look like, is there some other way that can be handled? Could she have can a caregiver just come in and help her out? Is she willing to do that? And no other person is able to help out. So it's an option, but like anything else, it's really only meant to be if it's likely to prevent real harm, and something else can't be figured out without it. And that's true just like with the, again, like the minor guardianship, if you're asking for it, there is that option to ask for the immediate order obtained ex parte. But that, just like the minor guardianship, you're going to have to show that there will be substantial harm before a hearing is held. So that's a pretty high burden. It has to be something pretty extreme. But like the minor guardianship ex parte immediate appointment, you're going to need to have notice within 48 hours to the person and their attorney, and the return hearing scheduled in 5 days. So an option, but pretty significant things that have to be shown. There is also the option of the emergency conservatorship. So if we're thinking about Annabelle's situation with the leak in the roof, what kind of leak in the roof is it? Is it something where, it's some drip and it's like, well, we need to get this taken care of in the next few months? Or is it something where there is a real problem and the house is going to suffer significant damage, really substantial damage, because this water is pouring in and it's blah, blah, blah. So in that kind of a situation, then maybe emergency conservatorship is something that needs to happen, because there's gonna be this real harm, and there's no other way to get this fixed. I can't just go in and do it. All right. A couple things to note, though. If there is the emergency guardianship or conservatorship, the person's entitled the law states that the court is going to appoint an attorney, but the petitioners are going to want to make sure that an attorney is appointed for that person right away. And of course, the time changes, frames are a bit different. So instead of having it 60 days, in Washington law, even an emergency guardianship is not super fast, because it's a minimum of 14 days notice to the respondent, their attorney, and court visitor, unless you're getting that immediate order. And of course, the state model forms are just like for minor guardianship. It's a separate set of forms if you're going the emergency guardianship route. And if we're thinking about Annabelle, so as opposed to Jeremy's situation, remember I noted that the petition is going to have this Appendix A that's going to say, well, here are the people that you need to give notice to, you need to get served the petition and notice of the hearing and all of that. And so you can see this is a pretty long list, starting with, spouse, domestic partner, adult children, certain adult stepchildren, adult caregiver, attorney, REPA if they're trustee or custodian. Was there somebody that the person nominated? But as I mentioned earlier on, the people in this list are all, to the extent they can be identified and known. And so if someone's filing for this guardianship and conservatorship, who's pretty close to the person, they may know all these folks, but maybe Meredith and Rob, live a few counties over, and they don't really know, does Aunt Annabelle have an attorney? I don't know. That's something that they may not know. So these are people that have to be notified to the extent known. The court visitor will, once appointed, would probably be able to find out more of that information. So that was a roughshod run over a couple of scenarios and a lot of information. I'm certainly willing to take questions to the extent I can answer them, but I mostly want to say thank you for your time and your attention, and especially your talents in helping folks in these situations. So if there are questions, I'll be happy to answer them. Up in the chat. Yes, I will send out the copies of the slides, and the other thing that I will do is send you a copy of the link for these kind of monthly information sessions that we're doing, both for folks who are going into the petitioning process and for folks who are needing to do their reports and are kind of struggling with the the new report forms. We do kind of informal presentation of information, and people can ask questions, and as you know, that can be a lot of different questions. I am in the process working on recording those as well, so they'll be available 24/7. They aren't just yet, but we do have the monthly sessions, Zoom sessions like this that folks can do. And I will send those to Shelley and have those out. Okay, great. I see another question here. A comment. I have an 18-year-old Down syndrome. Pay up and power may move to do some get appointments for her. Okay. Oh, okay. So someone who has a situation. Yeah, and it's both more complicated, but probably more satisfying when folks really are trying to figure out some of these situations. And like I said, anybody's welcome to attend those monthly Zoom sessions where we talk about some of the pros and cons of those different situations. And also the Washington Law Help kind of goes through the pro cons, because it really depends on that individual situation. And if the person has things about supported decision making, is that they don't have to use it, and so is that something that works for them? If they have the capability and they can, that's great. But they may need more protection than that if that's something that they, absolutely shouldn't be making decisions for on their own. So there's a lot to think about there. Okay, well, great. Well, it sounds like there's a lot of folks with questions and some personal experience. And yeah, it is a lot of information, and it is kind of going back to where we started out with in the beginning, is that every situation is different. And so I think that's probably, especially as a facilitator, can be challenging, because if we're thinking about it, even your own situations, but others, there's nuances, there's things, and people can come into situations with, I was told I need to do this, and they haven't really had a chance to think about those other options and whether or not it's the right fit. But there isn't really definitive answers. I mean, it's something that folks should try and think about and consider. But if it's something that isn't working and they feel that they can file a case, but they're going to want to have thought that through before they go to the trouble of filing a case and starting that process.